employment or anything like that.
Thank you. I guess we got a question from, when we submitted prior to today's session, is that some folks, depending on their country and their story, get denied a B1, B2. Do you think that can affect their chances at getting a B1, B2 in the future, or any other type of visa that allows someone to work in the US?
So a visa denial at the embassy level or at a consulate can cause a problem in terms of, first of all, not getting the visa that you've applied for, but also for future applications. But I would encourage, someone who's gone through a denial or who's had a problem, you can always try again if an officer made a decision erroneously or didn't, consider all the factors of your particular circumstances. I think it's worth it to try again. And you can always try and explain away the problem, whatever it was that you encountered the first time. It's not uncommon, especially in this day and age, to have a B1 or a B2 denial at the embassy. We are living in precarious times, and on a non-immigrant visa, the officer really wants to see that you're going to the United States temporarily, that it's a short duration, and that your plan really is to return to your home country. So I would encourage someone who had a denial to apply again, really be prepared for the next meeting. It can be frustrating because sometimes you don't get much of an opportunity to present your documents or things like that when you're at the embassy because they have very limited appointments. But I would encourage someone to try again, even if you're trying for a different kind of a non-immigrant visa to come to the United States.
Sounds great. Thank you. On that note, let's shift to another type of visa. I think it's probably now the most common type of visa that any IMG seeking a residency or a fellowship will be on, which is the J1 visa. So at least to start, if we would like to talk about what exactly is a J1 visa, some of its advantages, disadvantages, who is eligible for it, and we'll tackle the rest as we go. But at least let's start with those three main questions.
Sure. So a J1 visa is a kind of non-immigrant visa. So it's a temporary visa to the United States for the purpose of engaging in some kind of foreign exchange. So the program was sort of built on the premise that someone would come to the United States, receive some training, some education, and then take those skills back to their home country. So if a program is sponsored by the State Department and J1 visas are granted, they're granted typically for the purpose of training, graduate medical education, different kinds of training. There are different kinds of programs in different places, but it's all on the premise that someone is coming to engage in foreign exchange. So I think in the field of graduate medical programs, many institutions opt to grant these kinds of visas because the whole program is overseen by the State Department, and it's not the individual hospital or the individual institution that's taking on all of the liabilities of the sponsorship of someone who's coming here on a visa. So I think from the perspective of the employer, that's beneficial because the program is really overseen by the State Department.
Okay. So how long does it typically last? And you already answered who sponsors it. And I guess the subsequent question to how long does it last is what is the maximum duration of a J1? Because it's relevant to folks that come here for training and say they need a certain amount of years on that status, and sometimes they get stuck because they can't renew it or extend it.
Sure. So a J1 visa, typically a J1 visa could be issued up to 7 years. The challenging part of the J1 visa is if someone is coming to the United States and their program is going to render them subject to what's called a 2-year foreign residency requirement. So you have to be careful when you're coming to the US to see whether or not you're going to be subject to that requirement. Because if you are, you're going to be required when your program is completed to either return to your home country for 2 years or try and waive that requirement. So it is possible for people who are not subject to that requirement to change from one visa to another. But if someone is subject, it's a lot more challenging. It's a lot more complicated. And you have to see if it's possible to waive out of the requirement.
On that notice of waiving the requirement, what are the options? For example, if someone does have a requirement, like how can you waive it, and what types of waivers are there? And how easy can they switch to another visa form or potentially a green card?
So there are different kinds of waivers for someone who is subject to a 2-year foreign residency requirement. There is what is called a hardship waiver. So if you were in a situation where you were just, say, for example, you had a US citizen spouse or a child or someone who, if they had to return home with you, would experience some kind of a hardship, you could potentially qualify for a waiver based on that. There are waivers, especially for physicians who work in underserved areas or who are committing to working for certain government agencies, federal government agencies, state public health departments in areas that are underserved traditionally and need physicians, in particular, typically primary care physicians, psychiatrists, in some places OBGYNs, because there are shortages of US doctors. So that's a possibility to try and obtain a waiver to a J1 through a commitment to work in one of those areas. There is a waiver based on persecution, which is, sort of less common, more difficult. It's a very high level of burden to show the government that if you had to return home to your country, that you would face a real risk to your personal health, physical health. But that's another kind of a waiver to a J1. But typically, if there's a federal agency, a federal government agency here in the U.S., or the Veterans Hospital, or through a state, through the Conrad waiver program, it's possible to apply through the State Department and obtain a waiver to stay. And then if the waiver is granted, you would be able to switch to a different visa and continue working. And then ultimately, hopefully, if you wanted to remain in the United States, to obtain permanent residency.
Okay, so that's the key step, basically, always to try to switch from a J status to another form of visa status.
Right.
All right. I guess one last, question, because a lot of us that come to the U.S., we already have young families, we have spouses. So the question is, the dependent or the partner of the J1 holder, what kind of status would they be on in the US? Would they be able to work or study? And on that note, like, what is an EAD and how can someone probably get it?
Sure. So a dependent of someone who's on a J1, if it's a spouse or a child under the age of 21, would be eligible for the dependent visa. And their stay in the United States and all of the requirements that they're subject to would mirror that of the applicant, of the person holding the actual J1. And a J2 spouse would be able to obtain work authorization by filing an employment authorization document with the Immigration Service. So in the United States, there are certain visa categories where someone is eligible to work, but they require sometimes an additional step of actually obtaining a work authorization. So it's a document that you apply for based on your visa status through USCIS. And the processing times over the last few years have been very long, but USCIS is trying to work through the backlog and get cases moving more quickly, so that their goal is to process them within 90 days, although they're not at the goal yet, but that is the goal. And potentially, at least according to guidance issued earlier in the year, they might even allow people to what's called premium process for work authorizations, which is just an expedited kind of a processing with an extra fee to obtain their work authorization so that they could actually work in the United States, get a social security number, a driver's license, and be able to work independently.
Okay, we do have a question in the chat, but I will say to that person that we will get to that question in our thought process, and if it's not answered, they can let us know. Shifting gears now from the most common probably visa to another common visa, but probably nowadays is becoming less common in the medical world, which is the H-1B visa. I know that probably sometimes it's a bit maybe harder to get that type of visa, and now, as you mentioned, probably institutions are becoming less and less interested in sponsoring such a visa. But again, let's tackle this type, this visa type the same way we did with J1. So what is an H-1B? How can someone get it? Who is eligible for it? And what are its advantages and disadvantages?
So an H-1B visa is a visa that's for someone that is a member of what's called a specialty occupation. So typically it's an occupation that requires at least a bachelor's degree or the equivalent of a US bachelor's degree. This program is subject to a quota. So every year there's a certain amount of visas that are available, which is what makes it a little bit more complicated to obtain. So there are 65,000 visas usually every year available to people applying for them, with an additional 20,000 for people that have graduated with a master's degree or higher in the United States from a US institution. The benefit of an H-1B is that there is no 2-year foreign residency requirement. It's not a foreign exchange visa. You can work directly for the employer, and the employer sponsors the visa. Without that burden, it's a pretty straightforward pathway to obtaining permanent residence in the US so that you could remain here permanently and work and live, and then ultimately get US citizenship if that's your goal. So the H-1B visa is a very good visa. It's a strong visa. It does not have as many limitations as a J, but they are more challenging to come by, making them, 3 or 4 times as many people apply for them as there are visas available. So it's not so simple to obtain an H-1B.
Are there other types of H-1B visas that are not restricted to a quota, or everybody kind of has to go through the same process?
Yes, so there is a carve out for hospitals, organizations, nonprofits that are affiliated with academic institutions. So physicians are in a good position because if you are working for an institution that's affiliated to a university, like a hospital, an academic medical center, that is not subject to the cap of H-1B visas every year, there's a carve out. So they are not subject to the cap. So they can apply for H-1B visas whenever they have someone that they're interested in sponsoring. And that involves, filing the application with the Immigration Service. You could potentially premium process it and get a decision very quickly. And someone could change their status while in the United States. You don't need to leave to have a visa issued, and you could work for the employer. So there is a great benefit in that area.
Okay. And what is the maximum duration of H-1B typically?
So typically an H-1B is granted for 3 years, and then the employer has the option of extending it for another 3 years. If someone is working in an H-1B and they have an employer that's willing to sponsor them for permanent residence, if you begin that process, there are certain situations where if you begin the process and the permanent residence application has been filed and pending for over a year, it's possible to extend an H-1B beyond the 6 years. So there are certain situations where it's possible to go beyond the 6 years and to continue working as long as you're working in compliance with the H-1B visa terms and conditions. but typically it's 6 years.
Okay, and a similar question, I guess, to the J1 question in terms of dependents. Like if someone is the spouse of an H-1B holder, like what type of visa they would be on, their status, can they still apply to the same work authorization you mentioned with J1, and can they work and study beyond that?
So typically the dependent spouse, and again, the children, any child under 21 could file for an H-4, and their stay in the United States would mirror that of the principal applicant. And H-4 is not work authorized normally, but there are certain situations now where it is possible to obtain employment authorization, again, in the context of permanent residence, and if someone has begun the permanent residence process and has what's called an I-140 immigrant visa petition approved. In certain circumstances, it's possible to obtain work authorization, but generally speaking, an H-4 is not work authorized.
Okay. I guess Dr. Choueiri asked a question just in terms of numbers. We talked about the 85,000 that are quota per year, but in terms of total H-1Bs, is there an idea of a number that are sponsored every year?
I don't know how many H-1Bs are granted that are not subject to quota a year. But I mean, it's something I could certainly look into, and I could get back to your organization with an answer.
Okay. I guess the last type of visa type that we wanted to talk about, which honestly, I personally don't even have a lot of experience with, is the O1 visa. You know, we hear about it in some institutions that it is an option, if obviously an institution is willing to do that, to sponsor that. And I've seen it in, in trainees that are not willing to do a waiver, and they want to still continue their work in academic institutions from a J status. Mm-hmm. So I'm just wondering, we don't have to talk too much about it, but like what is an O1 visa, and who is eligible for it, and who sponsors it? As it compares to the other common, more common types of visas.
Sure. So an O1 visa is for somebody with, it's a non-immigrant visa like the other two visas, so it's temporary, but it's for someone that has extraordinary ability, in this case, typically in the sciences. So it is another visa that allows someone to live and work in the United States without limitations. So typically an O1 initially is granted for 3 years, but someone could renew an O1 indefinitely. There's no end. There's no maximum amount of time that you could be on an O1. And it is also possible, another unique characteristic is that you could switch from a J1 to an O1, even if you're subject to the 2-year foreign residency requirement. So it is an option for people who really are amongst the small group of people who are really at the top of their field. So it's more complicated to obtain an O1 visa than it is an H or a J, just because the threshold, the standards are much higher. So you really need to show the government a certain set of characteristics that you have really risen to the top of your field, that you've published a lot of research. There are a whole bunch of different ways, that you've won awards. There are a bunch of different ways you can demonstrate that to the government, but that's really what the O1 is all about.
Okay. And how can someone switch from an O1 to a different, visa? Like, how can you, I guess, go from O1 to a permanent resident or a different type of visa?
So you can have an O1, and as long as you don't have any kind of a 2-year foreign residency requirement that you have to waive, you could pursue the permanent residence process. And someone who is has filed for an O1 and who has been granted an O1 has a strong argument that they would qualify for the first employment-based category of permanent residence filing. So someone who has what we call an EB1, they qualify in the highest of the employment-based quotas for the first part of getting permanent residence in the United States. So it is definitely possible to have an O1 and to pursue an avenue to be able to live in the United States permanently and remain here.
Okay. And last question about the O1 is also what happens to the dependents of such, like if they were on J and they switch to O1, what happens to the J2 holder when that happens?
Sure. So dependents, they follow, their status in the US follows what the principal applicant has and holds. So if someone switches to an O1, then the dependents would be what we call an O3, and they would not be work authorized. However, they are allowed to study in the United States, and they would be allowed to stay here, you know, for the same duration as the principal applicant, the principal O1 holder.
Okay. Shifting gears from visas to actual green card applications, and how can one go from, you mentioned a lot about it, like how can one navigate from a visa to a green card, or how they can apply. I guess let's a bit talk more about that. So you mentioned I-1, you know, the I-140. So can we tell, you know, our listeners, like, what is an I-140 and what are the different types of it that one can apply for?
Sure. So in immigration, everything is a forms-based process. So every form has a number, and there's a whole bunch of forms, and it's, you know, everything is very form specific. So an I-140 is just one of the numbers of one of the forms that is the beginning of filing for permanent residence in the United States. So an I-140 is actually the immigrant visa part of the filing, and it can be an employment-based filing, or sometimes people are allowed to self-sponsor. So for the clients that I have and for the people that I see, typically the goal is to come to the United States to be able to try and get your permanent residence because people want to stay here, and then ultimately to get US citizenship if that's what they decide they want to have. So this part of the process is important, and there are many different avenues that you can take, especially someone who is a medical graduate. I think strategically, a lot of it is very fact specific, so it sort of depends what you are focused on and what area you work in. There are, you know, people who can file because they have extraordinary ability in the sciences, and they're, again, the part of a very small few who are in the top of their field. There are national interest waivers that someone could file to tell the government here that the work that they are working on, the research that they are conducting, what they're involved in, is in the national interest of the United States, and they should be allowed to stay here because what they're doing benefits this country. There are employment-based visas where a hospital could say, or a private practice can say, we want to sponsor you for your permanent residence, and they undertake the process of filing the I-140 and then ultimately getting the person their permanent residence. So there are ways to do it that are employment-based through the employer, and then there are ways that are also self-sponsored, depending on, you know, the specific factors in someone's case and where they are in their career and in their field.
Okay, and so on that note, so it seems that the I-140 is the more important form to approve, because subsequently it, you know, the I-485, which is the actual application for a green card, is like follows the I-140 approval. If that, but sometimes we hear that you can also file them concurrently. So can we talk about how they relate to each other, and like if you file concurrently versus like like one before the other, and how that's important in the process?
Sure. So like there are different categories and quotas in family-based cases, there are also quotas and certain amounts of visas released in the employment field, in the employment categories. So when anyone files for permanent residence, there are two different pieces of the application in the employment context. And one is an I-140, and the other is the I-485 that you mentioned, which is the actual application to adjust your status a permanent resident and actually get your permanent residence. So it is possible in certain situations to file both of those things at the same time. So if you're from a country where there is no backlog of cases and you have a current priority date, you can file both pieces of your case at the same time with the government. And you know, once the I-140 is approved, which typically happens faster than the I-485, the permanent residence application can move forward. And then once that's granted, someone actually becomes a permanent resident. But there are also situations where there are big backlogs for certain countries. And when someone files, you know, when it's time to file the I-140, the numbers are not current for the adjustment part of the case. So they have to wait. So
Okay.
every month, the State Department in the United States releases what they call the visa bulletin that will show you where they are with each kind of filing in the quota category. So we sort of file every month. We follow what's going on in the visa bulletin for people that are from India and the Philippines and countries where there are big backlogs and people can't file concurrently. And in those situations, we extend non-immigrant visas, such as an H-1B, so that people can continue to live here and work here until their priority date is current and they can actually get their permanent residence.
Okay.
I know it's complicated. There are a lot of pieces.
So what is the advantage of filing concurrently for the folks that don't have that backlog problem?
Well, I mean, the advantage of filing concurrently is that you will get your permanent residence faster.
Okay.
It just allows you to the process in a way that's more timely if your goal is to be able to stay here.
Okay.
Because, you know, we're looking at this through an employment lens. So all of these pieces depend upon your employment, and, you know, it gets complicated if you have a case that's backlogged and maybe you're not thrilled in your job and you want to move, but you don't want to leave because you have, you know, some immigration case, you know, that's keeping you there. So, I mean, it's hard not to be able, you know, to have to wait long amounts of time for your priority date to be current, you know, because of life, things that happen in life and, you know, your circumstances and your personal circumstances and your goals.
So just to review what we talked about with the visa, so who's technically eligible today to file for an I-140 or concurrently with I-485? So we talked about J1 that had met their waiver requirements one way or another, whether that's with hardship, persecution, job waiver. We talked that H-1B can certainly apply for it because it's the best kind of visa that allows for that. And we talked about the O1 visa, but I missed probably what you mentioned. Unless they have a waiver requirement, then they can. How can an O1 apply? I'm sorry.
No, that's okay. Someone on an O1, as long as they don't have a 2-year foreign residency requirement from a J, you know, they didn't switch from a J over, they can file for permanent residence as well. So, I mean, it's possible for someone that has an O1 visa to decide they want to file what's called a national interest waiver application for themselves. So a national interest waiver application is an I-140 that goes to the government, and you outline in it, you know, why it is that what you're doing is in the national interest of the United States and why you should be able to you know, be granted permanent residency here based upon that. So as long as someone was not in a country where there was a backlog and they were prevented from filing both of those things at the same time, you could file both of them at the same time. Okay.
And we talked about, you know, how certain individuals from certain countries might affect their ability to apply for the I-485 depending on, you know, their priority date and such. So I'm just wondering that we've been seeing more recently that there's a lot of delays in the processing times, even of the I-140 and the I-485, which is really, I think, affecting individuals trying to seek employment, you know, coming from certain types of visas. So is it current? Is it actual? Like, what's your experience with delayed since COVID probably, and shortage of staff. I don't know if you can comment on that.
Well, I mean, the backlogs, these are the biggest backlogs I've seen since I practiced immigration, which I've practiced for 16 years. So I think it's a combination of factors. COVID is one. There are these big backlogs that the government is trying to move forward. I think the processing through the embassies for people who are overseas and consular processing is a nightmare because there are big backlogs there. It's complicated even it's complicated to even get an appointment to have a visa issued overseas right now, just because the backlogs in the embassies and the consulates are so big. So the government currently is trying to work through the backlogs, and they're rolling out sort of new programs and incentives, such as premium processing for national interest waivers. And they're trying to make expedited processing and those programs more available because people have been waiting so long for decisions on cases, and it's not easy in the immigration context. They're trying to move things forward. So, but it's frustrating, and it's hard. It's hard for people who want to change jobs and who have other personal goals, to wait 18 months to get a decision on a national interest waiver is, it's not an easy thing to do. But the good news, I think, is that the government is trying to move things forward and to make new kinds of processing available. And there, for example, this administration has encouraged people that maybe couldn't get an H-1B or didn't get an H-1B, weren't selected, try and consider the other non-immigrant categories, such as an O-1, and try to look at other ways that maybe you would be able, to remain in the United States. But it's hard. I mean, the backlogs are big and it's easy. It's frustrating.
Sure. And are there restrictions for traveling, outside the U.S. while you have these documents pending? Whether it's the I-140 or the I-485, like, what would you tell your clients once they file, like, about traveling outside the U.S. until, for example, they get at least an approval or for example, the green card?
Sure. So I would say travel is still unpredictable. So, for example, when you're at the part of your case where you have your adjustment of status, your I-485 pending and filed before the government, for the USCIS here in the US, you can't leave this country without a travel document, or else you'll abandon your case. So that's a certain kind of a situation where you want to be careful that you don't leave without having a travel document with you so that you can re-enter the United States. If you have an H-1B visa, for example, and you're towards the end of the visa stay, you want to make sure that if you have an extension, if you leave the United States, you have to have the visa issued at the embassy or the consulate before you return. That inevitably is going to be a long process just because of the backlogs at the embassies and the consulate. So, it's really just, you have to be careful about unforeseen circumstances and potential travel delays right now. Again, based on every individual's different situations and circumstances.
Sure. And finally, to conclude that part of the session, so what are the advantages or disadvantages of holding a green card and earning the permanent residency status?
So when you become a permanent resident, that gives you the ability to stay in the United States permanently, to work here permanently, to live here permanently. And then ultimately, if you want to get citizenship in this country, once you've had, if it's an employment-based case, once you've had your permanent residence for 5 years, as long as you've been here and you have at least half of that time physically in the United States, you can apply for your citizenship. So, with that comes the right to vote and the right to stay here and not have to worry about sponsorship anymore through some kind of an immigration program. I think for someone that doesn't necessarily want to be here permanently, it's something that you would want to really look at seriously, because when you become a permanent resident, it's important that you not have an absence from the U.S. longer than 6 months in a row. There are certain rules and certain parts of regulations that the government looks to see if someone has actually abandoned their permanent residence, for example. So if someone leaves the U.S. for a period of longer than 6 months in a row, if they try to re-enter the U.S., they could be questioned by Customs and Border Protection and have, lengthy questioning about why it is that they were gone for so long if they're actually permanent residents. If you leave for longer than a year and you don't have a re-entry permit to come back to the United States, technically you have abandoned your permanent residence. And sometimes people just don't know that. So if it's not your goal to be here at least half of the year, it might be an option that you don't want to consider. There might be other avenues that would work better for you.
Sure. There was a question earlier in the session about if someone already started or about to start a waiver job, can they file like right from then for a green card? And can they do that on their own, or is it better to do it through the employer?
So if someone is, you said someone has filed for their waiver, for a J1 waiver, and the permanent residence process.
Yes.
So depending on the kind of waiver, well, really, whatever kind of a waiver it is, the permanent residence is not going to get granted unless the waiver is granted. So I guess, depending on what kind of a waiver you've applied for and how you are applying for permanent residence, you just want to be careful that all of those, the goals of all of those filings are the same. Because sometimes if people commit to working in an underserved area and they commit to being somewhere for 3 years and they sign a contract, and there are a lot of pieces that go into that, and you make a promise, to the State Department of Public Health that you're going to stay somewhere for 3 years and your H-1B becomes dependent on that. You just have to be careful whatever it is that you're filing for, because once you file an I-140, you're showing the government that you have plans to stay here permanently. So you just have to be sure that all of the goals of your strategy line up, I guess, is the best way to say it.
But if they do it through the employer, will that be different, for example, than if they filed themselves for it, for the I-140?
Oh, then if they file like an asset to self-sponsor?
Yeah, that's the question. So if they started, for example, they're on H-1B for the purposes of a waiver in an underserved area, and they want to seek permanent residence, can they at least start the process with an I-140, and can they do that like through an employer as opposed to them national interest waiver, for example?
If you're going through the same employer,
Mm-hmm.
as long as all of the goals align, I would say yes, it's possible. You just want to make sure that whatever part you are in the process, if you don't have a waiver yet, it's going to stop the permanent residence process at some point, because that won't be approved without actual proof of a waiver. So it could cause a delay.
Another question was the difference between the costs of J1 and H1 and who pays for it. I think we touched a little bit on it, but I'm not sure if we can formally answer that.
Sure. So with the H-1B program, the employer is undertaking the obligation to really pay the costs of the filing fees for the H-1B petition. So there are a lot of costs involved, and that's something that deters some employers. The beneficiary, so the employee, could pay the premium processing charges if they want to expedite the case, but really the costs for the filing should be undertaken by the employer. So it is a more expensive process because there are several fees involved. Okay,
thank you. There was another question about the 2-year home country return requirements. So it looks, the question is, if someone leaves the US for a waiver or to waive his requirement back home, as the requirement is stated, Can they work for humanitarian organizations and like outside their home country and return back to the US? And I guess the question is also like, who monitors the waiver when you actually go back home?
So the requirement is that you're returning to the country that you came from on the J1.
Right.
So ultimately, you know, if you leave the U.S. for 2 years, you should be eligible to apply to return in some capacity, maybe in a different non-immigrant visa, or to come back here a different way. But the government will know, I mean, they will have the length of absence in their records. You know, I think it gets more complicated, I guess, if you're traveling country to country and you're outside the United States, maybe to monitor. But generally speaking, the requirement is that you return home for 2 years. And then if you were applying to come back here in some capacity, the information, at least the departure and the entry, would be in the system.
But is there a way
you know,
to, yeah, sorry.
So, you know, and sort of following that thought, what's going to happen is, you know, you're going to apply eventually for a visa to come back to the United States. And to do that, you have to fill out a lengthy application, you know, through the embassy. You're going to have to fill out an application and go to the embassy to get a new visa issued. And on the application, it's going to ask you where you've been for the last 5 years or where you've lived. It's going to ask information about where you've been working. So, I mean, that information is going to come out one way or another, I would think.
But it's not like there's a program that you need to enroll in or, you know, be closely monitored.
No.
When you okay.
Yeah, no, just the requirement.
Okay, thank you. There is another question about, is there a way to expedite an EAD after one files for an I-485? And if yes, how can they expedite it?
Yes, so you can request to expedite a work authorization through USCIS. So there are a list of different criteria that the government will consider when they decide whether or not they want to expedite something. So if someone is having some kind of a, you know, personal emergency, if they're facing financial hardship and they really need to be able to work, they can explain that to the government and provide some kind of proof. They can request to expedite. If someone's inability to work is putting them in a position where they're about to lose their job, they can certainly request to expedite. So financial hardship to the person individually, financial hardship to the company, some kind of an emergent circumstance, you know, in your personal life, all of those things the government will consider. So you can definitely request to expedite an EAD, and as long as it's filed and you have the number that you can reference, you can either call the 1-800 the USCIS telephone number and request it over the phone. Now you can request to expedite it through their live chat feature, through their EMA function that they have on their website, and they will consider an expedite request. They might ask you, you know, for some documentary proof to show what it is that's causing the hardship, why it is that you need to expedite it, but it is possible.
Okay. Could someone change jobs using the employment authorization document that we mentioned before an I-140 is approved? So
you have to be careful. I'm just going to speak generally. You have to be careful about changing jobs before an I-140 is approved, I would say.
Okay.
Yeah.
Is there a reason?
Changing portability, it gets tricky. So the person would have to be working on a non-immigrant visa, presumably, right?
Yes, presumably.
Yeah. So once you start working on an employment authorization, you're departing from your non-immigrant visa. So your work authorization is based specifically on your I-485, which is pending. If something happens to that I-485, which if the I-140 gets denied, so will the 485 because it's dependent on it. Then your work authorization is not valid, and now you've gone off of your non-immigrant visa. So you have to be careful.
And then what happens in that instance? Supposedly you are waiting for an I-485, your I-140 gets denied, the EAD gets discontinued or canceled. Then what happens?
You have to file for some other way to be working.
Like an H-1B? Like, can someone salvage the situation with an H-1B, or they have to leave the country?
It really depends on the factors of the situation. But you have to be careful, because once you start working on an EAD, you're departing out of the non-immigrant visa realm, because what happens is if the employer is sponsoring your H-1B and you leave, you are no longer working on the H-1B. The employer is supposed to alert the government to tell them that that person is no longer working on the H-1B, so it will no longer be valid. So then you are working for a different employer on an I-485, based on an I-485 on a work authorization for an I-140 that's not approved. So if the I-140 gets denied and there's a problem, they're going to have to somehow file for another way to stay in the United States, or else leave the US and re-enter somehow on a different work authorized non-immigrant visa. So, I mean, it can get complicated.
Another question, is there a minimum citation count? I guess they're talking about research citations for an EB1 application.
There's not a minimum count. Those cases are really fact specific, and they cover, people that work in all different kinds of fields and all different kinds of professions, and not all of the evidence is the same, or the same kind of evidence. So there's not really a requirement about how many citations you need to have or anything like that. I think that, it's really important to be able to document the depth of your knowledge and, of your research and what you've done to put yourself at the top of your field. I think that's really important. So I wouldn't put a number on it. Yeah.
Okay. And then I believe we touched on that, but I guess there is another question about the O1. If you have a 2-year requirement of going back to the home country, if they want to change to an H-1B or green card, how is that different than the J1 with a 2-year requirement that wants to change to an H1 or a green card?
So if you change from a J1 to an O1 and you have a 2-year foreign residency requirement, that goes with you. So even on the O1, you still have the same requirements. So you can't change to an H1 and you can't file for permanent residence until you waive the J.
Okay. I guess those are all the questions on the chat. I still have 2 more questions before we conclude. So some institutions are not able to sponsor visas for a lot of the factors that we've already discussed, or even green cards. But other institutions solely rely on that. So per your experience, is there a reason why there's such a discrepancy or differences from institution to institution?
I think that what happens at an institution reflects the workforce in the area, and the labor needs of the institution, and what it is that they're willing to implement in order to hire people and to staff their facility. Some places just don't want to take on the liability of sponsoring people because they don't have the resources to do it, or they don't want to put the resources in place, and they just don't want to take that on. And some places do take it on. So I think really it's probably a reflection of the labor situation in the area, and exactly what it is that if it's a hospital, or whatever the employer is, whatever it is that they need to put into place to be fully staffed and providing services to the best that they can.
Okay. There's another question about the O1 renewal. And I think we already touched on that and mentioned that O1 can be indefinitely renewed as long as you meet the requirements of the government to prove that you earned your O1 status.
Right.
I think that answers, yeah, both. Sorry, go ahead.
Yeah, no, you're right. So anytime you're filing to renew a visa or to change a visa, it is always at the discretion of the government. So, I mean, in theory, an issue could arise, something could happen, but, typically, if someone's in an O1, they can renew it indefinitely, as long as they're in the same field, doing the same thing that they were with the initial grant of the O1, and, they haven't, drastically departed from whatever it is that they were doing. I think you can presume that it would be approved, but, it's always another application. It's going to be reviewed. It's another decision. So.
Okay. And so, when you apply to an employer, there's always this statement about diversity, right? Like, this employer does not discriminate based on race, based on sex, based on whatever. And my understanding is that this is based on probably the government's definition of diversity. So to what extent, international medical graduates or visa holders in general are considered part of institutional diversity, and how that relates to the former question that I asked, like, about why certain institutions rely, for example, on visa holders versus others that don't. And so I don't know if you can comment on that, but that's probably one of my last questions for the day.
I think that when you undertake a visa program like the H-1B visa program, I think that at least the employers that I've come across in my experience, the hesitancy is taking on the liability and the cost of the program. It's a lot of work for some institutions that just don't have the staffing, or they don't have the funding, or they don't have the resources, to allocate to doing those kinds of things. They don't know anything about what an H-1B visa is. They don't know how to obtain one. It actually creates, and the further you go up when you're applying for permanent residence, a labor certification, for example, it's a lot of work for a human resources office. And if they don't do it regularly and they don't know what's involved, it's a lot of work and it's a lot to take on. So I think that for institutions that do take it on, there has to be an understanding of exactly what's involved, and they have to have the resources and the staffing to put it into place. I think that oftentimes, and I've been surprised that in certain places they just really don't understand what the H-1B visa program is, and so people shy away from it because they don't understand. But when there's a need for it, when there's a need to sponsor someone, when they find someone that they really want, to employ, that's the opportunity to sort of educate someone and say, hey, there's this program available and you can do this. So I really think it's a reflection of the staffing needs and, the workforce in the area, and, what resources are available.
Okay, with no further questions, and with us covering a lot today and almost all the topics we wanted to talk about, I want to thank you, our guest speaker today, Mrs. Saliba, really for your excellent information and for your time. I wanted to thank also all the attendees. I really hope this was a helpful session and that was quite informative. And finally, I want to thank the organizers and IMG Oncologists for creating such a informative, an important session for visa holders and for IMGs more specifically. So thank you so much.
Thank you.